This is an application and appeal in the matter of FXS and Mulberry Bush Org Ltd.
My lords, may it please you, I represent the appellant, my learned friend Miss Walker, the respondent.
Yes.
This appeal follows the order of Lord Justice Lewison, granting permission to appeal the decision of then Miss Margaret Oby, now Miss Justice Oby.
Yes.
In relation to two associated judgments, June of 2024 and November of 2024. The first judgment addressed breach of duty and causation issues after a lengthy trial during which evidence was heard over 9 days, with submissions culminating on the 7th of March 2024.
9 days stretching over the best part of a year.
Indeed. The hearings were February, June 2023, February 2024, and then we had submissions in March. So yes, a considerable period of time. The trial had initially been listed with a time estimate of 3 days. In any event, the 9 days of evidence focused entirely on the respondent's extensive allegations of negligence. He advanced his case by 2 expert witnesses, a social care expert, Ms. Mackenzie, and a psychiatrist, Dr. Rippon. Dr. Rippon also contributed to the case on breach of duty, not just the medical issues. My lords, you're not concerned here today with that evidence, at least not insofar as it relates to the claim in negligence, because that aspect of the claim was dismissed. However, the judge did uphold the respondent's alternative case and found that he had been subjected to battery, so the unlawful infliction of force, on 3 separate occasions in the course of being restrained, and that he'd been subjected to false imprisonment on 14 separate occasions, despite only 2 such occasions having been identified within the pleaded case. There is overlap in that one of the occasions of battery is also an incident in respect of false imprisonment was established. The second judgment addressed the quantification of damages and costs, and the point of appeal in relation to that judgment lies on the principle of the award of aggravated damages, the appellant contending that that was inappropriate. I propose to focus on the principle rather than issues of quantification. In other words, if the principle is correct, then I don't seek to trouble your lordships with any further analysis. By way of background information, in summary, the appellant's school was established in 1948. It provides residential care and education for children of 5 to 13 years of age who've experienced severe emotional damage in infancy and early childhood. It's a place of last resort where all other forms of intervention have failed. It has a national and international reputation based on its learning and the provision of outreach services to other establishments. This appeal therefore raises issues of significant importance to that wider community of schools. In terms of the respondent, he was a child with autism spectrum disorder who presented with challenging and sometimes extremely violent behaviour. He was placed at the school by his local authority on an emergency basis in June 2008. He was then 9 years of age, and he remained there until September 2009. He was subject to an accommodation order under Section 20 of the Children Act, and so with voluntary consent of his mother, not his father at that time. His father subsequently gained parental responsibility in May 2009 and then removed him from the school in September 2009. It's also relevant to note that the school provided accommodation only in the week, and that at weekends the respondent went to a separate respite facility, also during holidays, although some of his holidays were spent with his father. In terms of how the school functions broadly, it has a multidisciplinary team providing a range of psychological and educational services, and much of the therapeutic work is integrated into the daily classroom routine, as appears to be recognised in the judgment at paragraph 51. In terms of further context, all of which I submit is relevant to an analysis of the incidents in question, prior to the respondent's admission, he had been displaying unpredictable and extreme and sometimes violent behaviours, which had escalated over many years. That wasn't in issue. The judgment reference is paragraph 56, where the judge is listing the points of agreement between the relevant experts. His mother had not been able to cope with him, despite extensive assistance from agency care workers, and neither could the foster carers that he'd been placed with, following her inability to cope. His initial period at the school comprised a 12-week assessment process, which he spent in Rainbow House, the assessment house, and from that point onwards, detailed contemporaneous records, known and described in the judgment as daily logs, were kept of his behaviour and provide a transparent account of all incidents and interventions involving him. And your lordships will have noted that the premise of the judge's findings was that she accepted the records as stated, as set out. She then applied her own interpretation as to how that narrative then amounted in her conclusion to battery and false imprisonment. But there was no issue as to the provenance of the daily logs. The purpose of that information was to give the school insights into triggers that might be setting off behaviour, to enable monitoring, and of course to help make improvements to the respondent's quality of life. And that is noted in not in so many words, but the judgment at paragraphs 9 and 36 provide that context. All children had a key worker, and Will Long, a witness in the action, was the claimant's, the respondent's key worker. And that provided for consistency. Will Long developed a close professional relationship with him, as can be seen in his witness statement and the legal transcript of evidence. The respondent was cared for by other carers as well, who would also be on hand. There were 4 houses, 7 to 8 children in each house, and a number of therapeutic care workers on hand at any one time. All of the carers were trained and experienced in dealing with severely disturbed children, and all of them by necessity were trained in applying physical restraint where that might be necessary. And the method of restraint used was, there is a long acronym to describe it, but the judge has used part of that acronym, PROACT. See paragraph 25 of the judgment to refer to the method of restraint taught by the school. This is a technique which teaches de-escalation as the primary approach, with the application of physical restraint only where necessary. And that particular methodology, the PROACT methodology, includes holding the child in a supine position, in other words on his back, but not in a face down prone position. The defendant's policy, which can be found in the supplementary bundle at page 87, clarifies, starting at page 92, that it is PROACT that is the restraint method used, and that that does not permit restraint being applied in a face down prone position. And so there's no issue that that is what the school's policy set out. Paragraph 50 of the judgment clarifies the point that in
Sorry,
fact...
when you say page 9,
May I just...
I think it is page. It might. Are the electronic and the paper bundles different?
well, they
It's
shouldn't
not page
be,
98. If you're taking us to the policy.
yes, may I just clarify that?
87 to 94 says the index.
You say 92.
If I can assist, it's page 93 is the
Thank
is
you
the
very much.
prohibition on restraint face down.
Thank you.
The policy starts in the electronic bundle at page 87. It's entitled Handling Difficult Behaviour and Sanctions.
And paper too. That's a good aim. Right. Do you want us to look at page 93?
Yes, please,
Yes.
my lord. It starts on the previous page, which I might direct you to at this point
Yes.
as well. The heading Sanctions Used Include. So there we have the list of sanctions. I may need to come back to that. Then on the following page, under the heading at the bottom of the page, guidance on the use of physical restraint. Only use a physical restraint if you've been trained in the use of CROAC, SKIP, RUK. And then on the following page, bullet point 3, it is not permitted to restrain children face down.
Does the PROACT document talk about prone, or does it simply talk about supine restraint?
Just supine. So the technique is to seek to put the child on his back, not to seek to put him in a face down position.
So we've got the relevant bit of that document anyway.
We don't actually have the PROACT document, and I don't think it was available to the court either. It wasn't in dispute that that was the position. Lord, the school subsequently changed to another restraint methodology. There are a number that are used by such establishments. They subsequently changed to a methodology that did permit and did teach face down restraints, and that is clarified in the judgment at paragraph 50. The evidence of Mr. Lowell, and also clarified by the evidence of Will Long, paragraph 10 of his witness statement. The school now using a face down restraint method which is more effective. So that was the evidence on the restraint. Well, there's more evidence in relation to the restraint technique, but in terms of the headline points and the fact that the school subsequently switched to a different system, not for reasons connected with this case, demonstrates that there are a number of legitimate means by which restraint can be applied in this type of situation. And so,
Sorry, have we got that document?
no, we don't have any of the actual teaching documents, simply the defendant's policy.
And will we be right to assume that the staff have different training in relation to that technique in order to implement?
Yes, any of these restraint techniques require staff to be trained, and the evidence in this case was that they were trained in the PROACT technique, that training was refreshed on a regular basis. And, your lordships will have noted that the staff employed at this school were all very experienced, and many of them highly qualified in terms of having academic qualifications. The respondent settled down initially very well at the school. His behaviour, however, escalated. The appellant contended at the point at which his father came back into his life, so somewhere early to mid 2009, and the steps that had been achieved in the earlier weeks became eroded. The problem was that the respondent's father did not consider the school to be an appropriate placement for him. He did not consider that the school were taking sufficient account of the respondent's autistic spectrum disorder, and he did not accept that the problems were emotional and behavioural, and on that basis eventually removed the respondent, contrary to the wishes of the local authority who had placed him there in September 2009. In terms of the evidence before the court to that effect, there was a significant amount of evidence in the witness statement of Will Long, paragraph 31, the witness statement of Carol Day. She was the head of group living and supervised the care workers, the therapeutic care workers in all 4 houses. So she had direct experience of the respondent. Also the statement and evidence of the head teacher, Andrew Lowell. And so the children at the school would go to classes during the daytime as would any ordinary school child, and they would then come back to the houses in the evening to live. So all of those witnesses were of the definitive opinion that the behaviour had escalated in that context. That point is also evident and set out quite clearly in the looked after children statutory child care review, page 71 in the supplemental bundle, and I apologise if I don't correct hard copy bundle to hand. If your lordships have that
Yes.
page, this is a
Days of meeting 18th
the
May
18th of
2000.
May, and so if I might, direct your lordship's attention first of all to page 73. It's internal page 3, under the heading Current Care Plan,
Yes.
which indicates the fact that the father now has parental responsibility. The school would like the respondent to remain and continue to spend weekends at Ashley House. Next paragraph, the father raised concerns that the respondent has ASD and needs to be in a school that specifically provides for this. There's a discussion on the following page, further discussion making the point that I've already made about the issue as to the respective contribution of the ASD and the behavioural issues and tension arising there between the father and the local authority, who were currently considering an application for an interim care order. That's just under the heading Health. That's the might I just take you further on to page 77 to encapsulate the point relevant to the escalation in behaviour, just after the subheading Contact. The father stated that the respondent hates boarding school and he, as a parent, had a right.
Sorry, I've lost where you are now.
Beg your pardon.
Give it to me again.
Internal page 7, my lord.
Thank you.
Just above the subheading Contact. The father stated that the respondent hates boarding school and he, as a parent, had a right to make choices about what school his child should attend. It was also commented that he picked up on the issue that he may be moving in with his father in July 2009, and he will be attending another school. Since obtaining this information, he's taken it literally and now understands that will happen. This has caused great problems with his behaviour. He functions well when he knows exactly what is going to happen, but a sense of uncertainty has now been introduced. In the last 2 weeks, his behaviour has been extremely difficult.
Yes.
Oh, thank you. May I turn to the pleaded case to establish the framework within which all aspects of the claim were put. Your lordships understand that the respondent made wide-ranging allegations of negligence about most aspects of his care at the school, and in that context, he cited numerous occasions on which he'd been restrained. Paragraph 17 to 43 of the particulars of the claim. If I could direct your lordships to page 124 in the electronic bundle. Is where that
Yeah.
document begins, and paragraph 17, under the heading physical intervention and other strategies used by the school, the reference to the incidents, the 28 incidents, described as not being an exhaustive list, that's paragraph at the end of paragraph 17, were designed in the first instance to support the claim for negligence, the overarching points being that the school had failed to sufficiently understand the respondent in the context of his ASD. They'd employed strategies that weren't appropriate. They'd failed to seek advice from other professionals, and that if they hadn't been negligent, it wouldn't have been necessary to restrain him. I'll come on to the causation point in a moment. And the second alternative part of the case was that in any event, those restraints constituted assault, battery, as well as being negligent. And the evidence that I've already referred to you from the expert witnesses heard over the 9-day period was focused on the issues that I've just identified, which are specifically or broadly set out at paragraphs 49 to 54 of the particulars of claim. Electronic bundle page 132. Under the heading particulars of negligence. There was another aspect to the claim which fizzled out, that the school's failure to meet the respondent's needs had caused him to exhibit sexualized behaviour, but that after the evidence that it wasn't conceded but seemed to fizzle out and didn't come to anything. And so the criticisms made of the school were multiple and wide-ranging. They encompassed virtually every aspect of its practice, and the expert evidence that was necessary, perhaps not necessary to take 9 days, or the 4 or 5 days that it took to hear it, went in depth into all of those criticisms and issues. To square the circle, because of course breach of duty alone isn't sufficient to command compensation. So in terms of the impact of the alleged negligence, it was the respondent's case that the impact was, the effect was to exacerbate his challenging behaviour and to cause him to be admitted subsequently to a psychiatric hospital for 4 years and 5 months, when this would otherwise have been avoidable. Paragraphs 58A and E of the particulars of claim. The case had originally claimed damages for pain, suffering, loss of immunity. It was framed as a claim for personal injury, and all the way even through to submissions, despite the fact that the experts, by the time the matter reached trial, had agreed that in fact there was no injury. Damages were nonetheless claimed for pain, suffering, loss of immunity in the sum of £140,000. During the trial, when it was becoming apparent that actually the respondent might not be able to establish any injury as such, the appellant's witnesses were cross-examined on the basis that injury had been caused by the restraints. So in other words, bruising and such like. That hadn't been pleaded. Neither of those routes were successful. The judge identifies at paragraph 39 of the second judgment that the claim had been put in the sum of £172,776. In any event, the judge dismissed all of the allegations of negligence, whereby the claim to personal injury fell away, and neither was it established that injury had been caused by bruising in individual incidents. The judge's analysis of negligence is at, in the first judgment, at paragraph 59, and then her findings appear at paragraphs 132 to 141. The respondent relied on the same factual allegations as had been relied upon in the claim for negligence, as constituting assault, battery or trespass to the person of false imprisonment, and paragraphs 55 to 57 of the particulars of claim set out that assertion.
55 and 56, is it?
Paragraphs, I think, on 55 to 57 of the particulars of claim.
To 57, I see.
Under the heading particulars of assault and or battery and or trespass to the person. So some particular attention is drawn at paragraph 55 to 3 incidents, although the claim, as I've already indicated, set out a non-exhaustive list, the list itself comprising 28 incidents. In terms of the evidence relied upon by the judge for her findings of battery and false imprisonment, that can be readily identified, because the only evidence available to her was the daily logs, and so the contemporaneous records. They amounted to almost 900 pages in the trial bundle, describing numerous incidents in which it had been necessary to restrain the respondent in the context of his challenging and violent behaviour. And the second plank of the evidence came from cross-examination of the appellant's witnesses: Andrew Lowell, the head teacher, Will Long, the key worker, and Carol Day, the head of group care. Other witnesses were tendered and cross-examined, but not on these issues. The appellant is concerned that the judge was invited to make findings and did make her findings with potentially serious consequences based upon an interpretation of records that were 15 years old, and without any evidence from witnesses who were involved in the relevant incidents. Will Long, although of course may not have had any recollection of specific incidents, Will Long, the key worker, was directly involved in some of the incidents of false imprisonment. But surprisingly, he was not cross-examined about them. And so the only person tendered as a witness who actually had been involved in some of the incidents was not cross-examined on that basis. He was cross-examined about on numerous other issues, but not that very important point.
Sorry, which very important point?
The assertion that he, to the extent that he was involved in particular incidents, had falsely imprisoned the respondent. He appears as the author or a contributor to some of the daily logs, which the judge subsequently interpreted as constituting false imprisonment.
Did he address the towel aspect of the incident
Yes, he did,
in his
yes.
witness statement?
Yes, my lord, he did. I can take you to the references. Would it be convenient to do that now?
If any of them are recorded in the judgment, then we could go to that. If there's something which wasn't in the judgment that you say should have been or would help us, then take us to that.
Would that be convenient now to go to the towel incident, or shall I just stick with?
As far as I'm concerned, whenever it's convenient to you, I understood your submission to be that
Yes,
it was significant that he'd not been cross-examined about it.
that is my submission. Yes, and
if that is right, and he said something in his witness statement which wasn't challenged on cross-examination, then we
Well,
be entitled to
let's
Well, I
have it.
can
We
take
could
it to you
spend
now,
a
it's
long
not-
time discussing whether to look at a particular page. Let's look at it.
yes, the
Well, you may not have it to hand.
I can have it
didn't
to
wish
hand.
to take you out of your turn.
Is it
Have
paragraph
references.
29 of his statement?
it's paragraph 29 of his statement, but I can take you to numerous. Yes, paragraph 29 of his statement, and then Carol Day.
Sorry, hold on. So it's paragraph 29 in which he says, refers to the
The towel method.
the town method, not often used, only as a last resort alternative if physical restraint was deemed to be ineffective or inappropriate.
Yes.
Excuse me, I'm just going to.
And your submission was that he wasn't cross-examined about that.
Yes, yes. May I just highlight? It's the paragraph after the one where he describes being bitten badly by the claimant. So paragraph 29.
Yes.
There were occasional instances when a towel was wrapped around the door handle of the claimant's room, enabling the door to be held slightly ajar, so that the claimant could be seen and spoken to inside, but could not open the door to attack staff. And then, as your lordship has read out, this method was not used often, only as a last resort. So the important points are it was a protective measure. The door wasn't closed. The claimant was in communication, or rather the carer was in communication with the claimant in that context. And that wasn't challenged because he wasn't cross-examined on that issue. I'm just going to go back to where I was just to keep some order to my submission so I don't ramble off at a tangent.
You're not rambling. Could I mention, as you may have noticed, the clock has stopped at 10:40. It's now 11:15 by my watch, but as I remember, as counsel, one would sometimes glance at the clock.
I haven't yet, my lord, but
Yes.
would you wish me to confine my submissions within a time frame? I'm very happy to.
Well, you should certainly finish within the morning.
That's not a problem.
Yes. Right.
Yes, thank you very much. I make the next point that by the time of the trial, of course, the expert evidence had crystallised, and the allegations of assault had been whittled down to only a handful of restraints. The judge eventually, as I've already outlined, finding that battery was made out in respect of 3 of those incidents. The reverse happened in relation to the allegations of false imprisonment, because although only 2 had been pleaded, they became expanded in the judgment to 14.
I think the pleading says at least 2.
Beg your pardon?
The pleading says at least 2.
Yes, your lordship's correct.
At that stage, had the respondent had access to the logs to be able to identify the
Yes.
number of occasions at the time of the pleading.
Yes, yes. My lord, I'm sure I've got better points than that, but the one of which is that the judge hasn't undertaken any analysis of the actual incidents. He just made certain assumptions without going into the granular detail of what actually happened. In relation to the second judgment, that is a point of principle that is objected to, and I'll come back to that when I've dealt with the substantive issues in relation to grounds 1 and ground 2. So first of all, hiving off the issue of the battery, I assume your lordships haven't had any opportunity to read the notes in question, which can be found in the supplementary bundle. So I'm now addressing the 3 incidents of so-called battery, and in the supplemental bundle, page 95 in the electronic bundle is covers the first incident, 16th of June 2009. I don't want to detain your lordships by reading out the
Well,
note in its entirety.
obviously, we're in your hands, but as I understand it, you're not complaining of the judge's findings of primary fact, like what happened. You're complaining of her conclusion that on each of 3 occasions it constituted a battery in
Indeed,
law.
yeah.
So it may be that there isn't a dispute as to what happened. I don't know.
It's an interpretation of what happened. That's the
All right.
point, which is an important point.
Okay.
Shall I just, by way of explanation, deal with the
Yeah, it's all right.
and
And if you
explain the nuances?
take your raincoat, you were going to SB 95.
Yes, it's the contemporaneous note in relation to the 16th of June
Yes.
2009. The time is 6 o'clock. We can see the location is the respondent's bedroom. He's trying to hit. He was separate for setting the fire alarm off. Started trying to leave his room, etc. Chrissy stopped him, Chrissy being the carer, by holding his forearms and reminded him he could only have the door open if he could be sensible in his room. He could not do this and started to hit and kick. Chrissy held him in a wrap, but this was not effective. To protect herself, Chrissy held him on the floor, applying some weight to his back. Chrissy called for support so that she could leave his room and hold his door shut until he could take control of himself. And the narrative continues. And then further down at point 8, the respondent was protected from hurting. And so the issues, the stark difference between the parties' respective positions was that the appellant's interpretation, as expounded in cross-examination by the witnesses I've already referred to, was that in this type of care setting, crisis situations frequently arise, and whilst the carers should, in the first instance, attempt to apply their training in order to apply an appropriate restraint, if that proves not to be possible for any number of reasons, it is entirely appropriate for them to do what they need to do to protect themselves, to take proportionate action to protect the child and themselves, and in certain situations to protect property. And so the appellant's contention, and this was the evidence of all of its witnesses, and no other witnesses gave evidence on the same point, was to that effect. The respondent's contrary submission was that because, and in this case, the respondent contended that applying weight to his back amounted to him being put face down. There was an issue about that, but if we take that at face value, the respondent's contention was that because the appellant's policy prohibited that sort of restraint, because that wasn't that wasn't the PRO-Act script, that therefore that rendered the incident, the carer's attempt to restrain him, unlawful. And that point was supplemented by the contention, which was disputed, that because the respondent was known to have violent outbursts, this couldn't therefore be described as the type of situation where an unplanned intervention had to be executed. And the appellant's response to that contention was that, well, that's not correct. Although we know that the respondent is violent, we can't predict when or how he might manifest his violent tendencies. And in the judgment, your lordships will have noted the judge referring to an incident where he, the respondent, suddenly and without any warning whatsoever, stabbed a gap year student in the face with a fork. And so the contention accepted by the judge that this couldn't be considered as an emergency type of situation where a dynamic risk assessment would need to be made and the carer respond as she could, that rendered the incident, permitted her to characterise the incident as unlawful, the unlawful infliction of force, and as a battery. And so that, in my submission, outlines succinctly the opposing contentions, the judge accepting the respondent's contentions on that issue. And the other two records, which...
Sorry, just before we leave that,
Yes.
can I press you a little? Obviously, deciding whether something is or is not a battery depends on exactly what happened. And
it does, yes.
the judge was in the difficult position, and the parties were in the difficult position of having to interpret this record as really the primary evidence on which to decide what happened. So if what you were addressing us on a moment ago is how this document should be interpreted, do I understand that the rival interpretations are that on your side you say it should be interpreted as Chrissy doing no more than what you described the witnesses talking about in general terms as responding to an incident in the only way reasonably available,
Yes,
if the primary means of restraint was not possible,
indeed. And
was not effective.
yes, and she, as pointed out by the witnesses, she had endeavoured to hold him in a wrap, which was a PROACT prescribed method.
Yes.
And she hadn't been able to, that hadn't been effective. And she then did what we see set out in the note. If I might just clarify, the provenance of the notes, there's no issue that what is written down is what happened. There are some peripheral issues about how we might interpret what happened, but we probably don't need to get bogged down in that. But the primary point is that is how do we then interpret that information and shoehorn it into a battery or false imprisonment.
Should we, for example, assume that she had not attempted to restrain him in a supine position, because otherwise she would have said so in the note?
Well, no, my lord, because this note wasn't written 16 or 17 years ago with this hearing in mind. It was written as a guide. It would have been reviewed potentially by Carol Day. She didn't review every single note, but her evidence was that actually there came a point where the respondent's behaviour escalated to such an extent, and Chrissy was having difficulty dealing with him in a physical sense. So her evidence is that she did was aware of that situation and did speak to Chrissy about it, but didn't have any concerns about her conduct. And so, if anything is to be elicited from that scenario, it is that Chrissy did what she needed to do to keep herself safe. She had dealt with the respondent on many other occasions. He was restrained on a total of 117 occasions throughout his time at the school, in the context of 550 recorded incidents of disruptive behaviour. She had cared for him on many of those occasions and had managed perfectly well with the physical restraint side of the matter. And so the fact that we're now whittled down after the respondent's significant efforts via his expert witnesses to pin criticism on something, we're now whittled down to these 3 incidents, and the evidence, the witnesses also pointed out quite properly that care is not just about physical restraint. The carers aren't bouncers, they're people with therapeutic skills who administer those skills to the good of the children in their care. And Chrissy, the carer in question, had a positive relationship with the respondent, and there was no concern at the time that that was a problem. And the respondent's father, has made earlier efforts to criticise the school, not in the same terms as in this case, but there's been a tribunal. He's made safeguarding complaints, and so contemporaneously there wasn't any concern by these very experienced, highly qualified therapeutic carers that what was happening as between Chrissy and the respondent ought not to have happened. So in my submission, there was no reasonable basis upon which for the judge to ignore, to dismiss the evidence of the defendant's witnesses that provided her with the best interpretation of those records. And also the other concern around the judgment is that whilst the judge sets out in short form her analysis of the evidence of those witnesses, and so in terms of the 3 that we need to be concerned about in this context, the head teacher judgment paragraphs 49 to 50, Carol Day judgment paragraph 50.
Lowell paragraphs
49 to 50 in the judgment. Carol Day 53. I beg your pardon, I'm just looking for the reference to Will Long, which I can't.
50.
Please, 50, yeah.
Beg your pardon, my lord.
Paragraph 50.
Thank you very much. Paragraph 50. whilst setting out an account of the evidence of those witnesses, they're very short, and they don't appear to be findings of fact, and neither does the judge go on at any other part of the judgment to make any determinations of fact in relation to that evidence. Her findings are in the context of her analysis of the torts of battery and false imprisonment, and with reference to the policy not being complied with, and the fact that these weren't crisis situations in her view, and so very difficult to understand how she has processed that evidence, other than ignoring the context which I just related to you. There's no dismissing of the context. There's no affirmation of it. Just no discussion at all about the context.
So this links in with your earlier submission that with no analysis of the individual incidents.
Yes, it does. Yes.
Well, is that right? I think she did deal with the circumstances of this sitting on the back, didn't she? Whereas I entirely understand your point
Yes.
on the 14 towel incidents, which she doesn't address
Yes.
individually and simply lumps
Yes.
it together.
She's characterised the sitting on the back as face down, and I've characterised that as a fairly peripheral point, because if we can accept that that's the case, that doesn't undermine the appellant's position. Whether sitting on somebody's back or putting them face down, it doesn't have any relevance to that contention. She was doing her best in a difficult situation. She, as the witnesses have identified, you have to make a dynamic risk assessment in a split second when you're being attacked by a very violent child, and you have to attempt to apply your training, but if that doesn't work, you have to do what you need to do to keep the child and yourself safe. Well, that is the point simply put, and as was put and elaborated upon and clarified by the witnesses in cross-examination, who were cross-examined extensively. For example, Carol Day, who gave evidence remotely from her ASD unit in Canada, was metaphorically in the witness box for half a day. She was then told that there might be another half an hour of questioning. We came back the following day and she was cross-examined for almost an entire day. And despite repeatedly being asked and challenged on the interpretation of the record, she maintained her position. She's a highly qualified professional therapeutic care expert who was responsible at the time for monitoring and supervising the therapeutic care workers, who must have been better placed to provide the judge with the context in which these incidents occurred than any legal submission.
How are we to approach this? We've got her witness statement. We haven't got got a note of her cross-examination. She gave you tell us, quite detailed evidence about how, from her experience, these notes were to be interpreted in relation to these particular incidents. Am I understanding you correctly?
Yes, there are.
How do we know exactly what she said about that?
Well, we have the transcripts, my lord, which I can take you to now, if that would assist. The
Yes, I hadn't appreciated that. I think, speaking entirely for myself, I would find it helpful if, at some stage, not now, I could be given just a list of the references, both in her statement and in her cross-examination answers, that you say provide the context that enables us to interpret
yes,
these records in the way you say they should be interpreted.
would that be helpful to be done now, or
Not now,
No, no.
but
stop now.
at some stage.
at some stage today, or subsequently?
If possible, if you finish, as we hope you will, lunch break, then perhaps during the lunch break, as you'll have shot your advocacy bolt, so to speak, you could perhaps get us these references. And
Certainly, my lord. Yes.
Ms. Foster and Miss Walker will know what you're relying on. All right, let's press on.
Yes. Further points of relevance to the face down issue. Are as follows. It wasn't an issue that the need to restrain the respondent on the 3 occasions was justified. And so we have the somewhat odd situation whereby on all 3 occasions, if the appellant's evidence is accepted, Chrissy, and it's Chrissy on all 3 occasions.
Miss Pusey.
Chrissy Pusey. She was faced with outbreaks of violence. She, in the first instance, attempted to apply her PROACT methodology. On those 3 occasions only, that didn't work. And she then had to resort to methods that weren't prescribed by the training and therefore by the policy. The policy arose from the training. The prohibition in the policy was consistent with the fact that the PROACT intended the ultimate position to be prone, not supine. And so we have the odd situation whereby what she did initially cannot be criticised, but then at some point we go into territory whereby she's subject to criticism, and the appellant contends that the judge has ignored that context. It's the same point I made earlier, but it puts the point into a starker reality when we appreciate that actually what Chrissy was doing, even on the respondent's account, was legitimate, probably for the most part, but then only became unlawful on the respondent's case at the point at which Chrissy departed from the training.
I understand why you say that in relation to the first and the third incident, in which there's talk of a rap, and then subsequently
Yes.
talk of what is or could be interpreted as being face down. In relation to the second one, it's not quite so clear that there are 2 stages. Page 96,
Yes,
you pick it up just above the hole.
29th of June.
Started trying to hit Chrissy in the face. Chrissy protected herself by holding the respondent in a wrap face down on his bed, and remained in this position for roughly 10 minutes.
Well, she's I'm sorry, I'm just trying to locate that.
I'm so sorry, page 90, it's in our bundles, it's page 96 of the supplementary.
The 16th of June.
29th.
29th of June.
Sorry, 29th of June, yeah, 7:25 p.m. So he's trying to hit a bite.
So speaking of that, just above the hole punch.
Yes, I've got that. Thank you.
So they're trying to hit Chrissy in the face. Chrissy protected herself by holding him in a wrap face down on his bed. He remained in this position for roughly 10 minutes before being
Yeah,
able
well,
to-
that I accept that's not quite so easy to characterise as a two-stage process, but it doesn't matter if it's two-stage or not. She was protecting herself, and she did have him in a wrap. And this is not intended to be a blow-by-blow account, encompassing every single movement and detail. That's not its purpose. So what we know here is that he was trying to hit her in the face. She had to protect herself, and we know that she had him in a wrap, and that he can't have been face down on his bed immediately. That must have followed from him being in a wrap. And we know the broader context that his behaviour had by this point escalated significantly, and although my differentiation point, whereby we have some clearer examples of what Chrissy was doing as being beyond criticism, and then at some point on the respondent's case falling to be criticised. The fact that other examples may not be quite so clear-cut doesn't erode the point, but doesn't erode the primary point, which is that in this type of situation, it's a crisis situation. You employ your training, and if you can't do that, you do what you need to do. The fact that we only have 3 occasions that the respondent has only ultimately was able to point 3 occasions where the carer's conduct could be drawn into question out of a far broader picture of multiple restraints, in my submission supports the appellant's contention. These carers are clearly not just doing what they want to do as a matter of course, without reference to their proper practice and training. I'm not sure if that answers your lordship's. And so it was only the face down aspect and the judge's analysis that these weren't crisis situations that resulted in her legal conclusion that these were batteries. In other words, the unlawful infliction of force. Just by way of completeness, the claimant relied on 2 policy documents. One, some government guidance that had been issued in 2002, supplemental bundle, page 81 in the electronic bundle.
81.
81. The first part of the document has been cut off. I don't think there's any dispute that the guidance was issued by some government department in 2002. We can see that it applies to a range of settings, It's guidance, it's not prescriptive, and that at paragraph 3.3, it's helpful to distinguish between planned intervention, in which staff employ, where necessary, pre-arranged strategies and methods, which are based upon a risk assessment and reported in care plans, and emergency or unplanned use of force, which occurs in response to unforeseen events. It was this document that was that sowed the seed for the respondent's contention that these incidents weren't emergency or unplanned incidents, because it was known that the respondent was violent, and the appellant submits that that's not a logical conclusion for her to have drawn, and that this document isn't making that point in any black and white sense. It's just discussing particular situations, but not in any prescriptive sense, and certainly not that would be relevant to the issues presently under consideration. And the judge's analysis is based purely on the 2 points. One, that the policy didn't allow face-down restraint. Secondly, that this wasn't an emergency or unplanned use of force, and that completely ignores the fact that you can't always plan as to how you might need to react. When you're a carer dealing with a very difficult, violent child in a crisis situation, and the second document that the judge relied on, I've already referred your lordships to. It's the policy document which prohibits face-down restraints because they're not taught.
Yes.
I also referred you in the policy document to the list of sanctions that are permitted. That may be relevant in the context of false imprisonment. And so the transcript references, I won't take you to them now.
Are you leaving this document? In other words, the guidance?
My lord, yes, I'm.
Because if you look at paragraph 3.1, and this is addressing the judge's conclusion that the town method was not a physical intervention. Paragraph 3.1 says different forms of physical intervention are summarised in the table below, and it includes, if you look at restrictive environmental change, forcible seclusion or use of locked doors, which might suggest that the town method is a physical intervention. Because it's a form of, not actually locked, slightly less than that, but it's a form of, I suppose you might say, forcible seclusion.
Well, my lord, again, we need to look at the context there, and this document is very generic. It cannot be used.
Yes, but what I'm asking you about, the judge said in paragraph 130 that she had real difficulty with the evidence of Miss Day and Mr. Vince that the town method was a physical intervention. I think on the basis that it didn't involve direct physical interaction between the child and one of the care workers. But this would seem to suggest that physical intervention is used much more broadly than that and doesn't require direct physical interaction.
Sorry, the TAL method didn't involve any physical contact between
I
the
understand
respondent and the
that.
carer. It was used precisely so that physical contact would not have to be employed.
But if one looks at 3.1, it would seem to be that it is within the definition of physical intervention as set out in this guidance. That's my reading of it.
But my lord, what happened in terms of the use of the towel method did not amount to forcible seclusion or the use of locked doors. The context wasn't that the respondent was being secluded, it was that there was a melee and the carers had to withdraw but still supervise the respondent, and they did so by looping a towel around the door, keeping the door ajar so they could see.
I understand all that. If anything, this is a point in your favour that physical intervention is used broadly in this document, and the judge misunderstood the meaning of the expression physical intervention.
I would argue against that.
Well, it may not be a point in your favour, because if we also look at paragraph 3.8 of this document, planned physical intervention strategies should be.
Yes, it
You
can't.
see a list of the things that the judge seems to have adopted. So the odd thing about the judgment
was that
is
it
on the
isn't,
one
but it
hand,
was.
It rejects.
Yes.
It rejects the idea that this was a physical intervention, but on the other hand, the judge does seem to have adopted what at least this document suggests should be done if it's a planned physical intervention.
Is there any help anywhere on the difference between planned interventions and unplanned?
Lord, no, I don't think
Because
so.
I speaking for myself, I have quite difficulty understanding what it's. We don't have the integrated treatment plan, do we?
Not in this bundle, no.
No. And did that refer to strategies and?
Yes, Lord, just in summary, the planned interventions were in accordance with the PROAC, and that is what the school used in relation to all of the children. So any local authority placing children at the school would be aware of that, and I recall that would have been entirely obvious and communicated to the respondents, to those with parental responsibility for him. And as far as the TAL method is concerned, the evidence was that that was also explained to the father. He didn't like it. It had been used on other children historically, because prior to its inception, a carer who had tried to hold the door open to achieve the same effect had almost lost their fingers. The child in question having tried to trap their fingers in a door. And so that's why the TAL method was devised. And the father was aware that it was being used. He complained about it. At one point, near to the end of the respondent's tenure, his social worker passed on that complaint at a meeting, and I can give you the transcript reference for that. But no, my lord, there's no nothing else to inform that point. But my lord, may I add that this 2002 document is one of probably many documents published by different government departments on this topic, and the fact that it's now gained status is simply due to the fact that it was relied upon by the claimant in this action. It's generic, and it should not, in my submission, be taken literally.
Now, I am getting worried about time. It's now 12 o'clock. You've been on your feet for 1.5 hours.
Yes.
We haven't got on to the law either on battery or on false imprisonment, or where you say the judge went wrong. We're still
Yes.
looking at primary documents and occasionally bits of transcript.
Yes, so my lord, I'll try to canter on, and I don't need to reinvent the wheel in terms of authorities, because my submission is not really very much to argue about there. But I'll just carry on in relation to the judge's analysis. I direct you to paragraph 93 of the judgment, where she identified that it was a matter of fact and legal submission. Whether the physical restraints amounted to assault or battery, whether the Tau method amounted to false imprisonment.
Sorry, which paragraph are you?
Paragraph 93. And the appellant admits that the judge's analysis of the principles at paragraph 61 to 62 ignores the principle of law that for a battery to be established, the conduct must be unlawful. She has, or appears to have proceeded on the basis that any touching, however slight, is sufficient to make out the offence. But in my submission hasn't gone on to square the circle by addressing the ingredients of the tort of battery. So the conclusion is premised on the assumption that any touching, however slight, is a battery, that the conduct was unlawful because it was contrary to the offender's policy, and it was unlawful because it didn't amount to an unplanned reaction to the event. And the authorities, the first two authorities in the authorities bundle, Collins and Wilcott, 1984, One Weekly Law, reports, page 1172, at page 1177, reference A to H.
Sorry, could you give that again?
Lord Collins and Wilcott. It's the first.
This paves the way for what Lord Gough said when he became Lord Gough.
7 in the bundle. Lord, the reference is at 1177, and the context was a police officer arrested a woman on grounds that were subsequently found to be unlawful and had touched her in order to attract her attention, and so it was necessary for the court to determine the definition of battery, and starting at A, the law draws a distinction in terms more easily understood, etc., between an assault and a battery. An assault is an act which causes another person to apprehend the infliction of immediate unlawful force on his person. A battery is the actual infliction of unlawful force on another person. And then further down, just before C, we are here concerned primarily with battery. It has long been established that any touching of another person, however slight, may amount to a battery. And in my submission, the judge has extracted that part of the judgment. Any touching, however slight, may amount to a battery, but she has ignored the primary criteria, the threshold criteria that one has to establish actual infliction of unlawful force. And the appellant's contention is that proposition is not contentious. It is reiterated in the following two judgments in the authorities bundle, which I don't propose to take you to because the point doesn't gain any further depth by repetition, and the judge's starting point was therefore flawed, and she should have paid heed to the context in which the incidents occurred, and she should have accepted the only evidence on the interpretation of the daily logs that was available to her. And if she had done so, she could not possibly have come to the conclusion that this was an unlawful application of restraint on the part of Prissy Lucy. And so for her to have inferred, which effectively is what she did, that if we assume that she had the correct legal test in mind, which in my submission she didn't, but if we assume that she did, and that she inferred the element of unlawfulness, then on the same basis that cannot be a sustainable conclusion.
Can I just understand what you mean by unlawful in this context, in the setting we're concerned with? Is it any more or less than using such force as is reasonable in the circumstances for the protection of person or property?
Well, my lord, no, that the judge didn't undertake any quantitative assessment of the degree of force used. She simply took against the posture, the face down posture. It's very difficult for the respondent to write the judgment in a way that would justify such a finding, because the judge's failure on many counts to provide findings and analyse the evidence in a way that would be coherent makes it very difficult to do that. But one can only, if one asks the question, what could the judge have found to make out a battery, it would have to be unlawful, possibly hostile, an intention to hurt the claimant. An intention wouldn't be required. Unlawfulness would be would satisfy the.
I'm just having difficulty understanding what you mean by unlawful. I mean, one can imagine in the setting we're talking about,
Yes.
in theory, escalating degrees of force where one reached a level which you would not possibly suggest was lawful. But that's, one can see that you can reach that through the prism of section 93, which the judge specifically quotes, and one must assume was applying when she came to that paragraph dealing with what wasn't reasonable. But if it isn't a question of, if the yardstick for lawfulness is not what is reasonable, what is the yardstick?
Well, it must be what is reasonable and proportionate.
Right.
It must be.
And if we look at, you say the judge didn't apply that test, but at paragraph 63, she specifically sets out section 93, which articulates that. And I quite understand you say she seemed to start with, to go straight to the policy and treat that as sufficient. But then at 119, she addresses the question of whether the face down restraint was or wasn't reasonable. I quite understand you may challenge her conclusions, but in terms of whether she applied the right test, where's the error of approach in that?
The error in approach is that the evidence before her didn't justify that conclusion. And it's not clear how the juxtaposition between her reference to the Education Act and her findings isn't clearly set out, or the section 93, power of members of staff to use force. They use such force as is reasonable in the circumstances, which is exactly how the appellant put its case before her. And so she hasn't, as such, undertaken an analysis of the incidents so as to address that test. But if we assume that this was in her mind, that she therefore took the view that it was unreasonable for Chrissy to do what she did, we still come back to the problem that the reason she considered it to be unreasonable is because it was against the policy and she didn't think it was a crisis situation. So either way, it's a circular point. It comes back to the judge's misconception as to how one ought to assess the issue of reasonableness.
Or possibly simply, on your case, a misinterpretation of the notes. Simple as that.
On the issue of battery, does the common law add anything to what we now find at Section 93 of the Education Inspections Act of 2006, page 195 of the bundle? Member of this is all schools, not person to whom this section applies, i.e. a member of staff, may use such force as is reasonable in the circumstances for the purpose of preventing a pupil from doing or continuing to do a number of things, causing injury to anybody else, causing injury to himself, causing damage to property, and so on.
Probably not, no.
The question is what's reasonable.
Yes, what's reasonable, yes.
Or what's reasonable in the circumstances.
Yes.
Of course, circumstances are not identical in all cases, but
my lord,
that's the test, isn't it?
Yeah, but we mustn't lose sight of the overarching point that all this happened by the time of the trial 15 years ago, and the fact that...
Understand that, but I'm not sure what is gained by taking a magnifying glass to the judgment of Lord Justice Gough in Collins and Wilcock, or for that matter, his lordship's observations in F and West Berkshire. It all comes down, as my lord suggested to you, to a question of what was reasonable in the circumstances.
I entirely agree. Your lordships will have noted I haven't taken a magnifying glass to the judgments. I don't seek to reinvent the wheel, and I don't need to make any further reference to the authorities. The indications of the judge's flawed rationale can be found in a number of parts of the judgment, which I set out in my skeleton submissions. May I just give you the paragraph numbers? I don't. exceed my time limit.
Yes.
So 107, 114, 119, where she concludes that the face-down restraints weren't reasonable for 5 distinct reasons, which we've already discussed.
And that's, I mean, I'm trying to remind myself, paragraph 119 is effectively her decision is right both in respect to battery and in respect to false imprisonment. Does she deal with battery separately anywhere?
I thought that was just in relation to that. False imprisonment findings are at 125 to 113.
Sorry, yes, of course.
119.
Of course, 119 is battery. Thank you. My mistake. 130 is the conclusion. Yeah, sorry, I interrupted you.
Thank you very much, my lord. And
Was she, sorry, before we leave 119, was there evidence which entitled her to find what she found at Roman 3? Like those demonstrates without appropriate triggering increases the risk of harm.
well, it was accepted that any restraint carries a risk of harm. I don't recall there was any specific evidence. That's why you need to be trained to.
I think she had referred to it earlier, but I can't put my finger on it to the particular risks involved.
Your lordship's correct. I do believe there was a reference in her judgment to that.
Never mind, we can look for it.
It's paragraph 119. Oh, sorry, that's the. I don't think beyond that there's anything. But the reason for the training, whatever methodology is used, is because physical restraint does carry a risk of harm. Mercifully, in this case, that did not ensue. And then paragraph 124, where the judge concluded that 4 additional incidents, which by the time of the trial was still relied upon as being battery, didn't amount to battery, and the reason for that was because they didn't involve face-down restraints. So that's the same point, but in a different guise. And then,
Well, what's wrong with that distinction? Presume you're very happy with 124.
I'm sorry, I couldn't hear your lordship.
You're very happy with 124. So what is wrong with the judge saying, for the reasons I've given in 119, face down restraint, you're unreasonable?
Because she's overlooked the context, which is that the carer didn't have any option. The carer did her best to protect both of them in that situation. And for a judge to reach that conclusion on the basis of documentary evidence alone is unreasonable in itself, because the incident would have, if one had been watching it at the time, have involved far more twists and turns than are simply noted in the daily logs. And then paragraph 134, towards the end of that paragraph, where the judge stated the restraints and physical interventions would have been lawful if the policy and 2002 guidance had been followed, or if the claimant's behaviour had been unexpected. And in fact, your lordship's correct in relation to, there is a reference to safety. It's in the second judgment, at paragraph 14, where the judge paragraph 14 of the second judgment, which is at page 101 in the core bundle. So this paragraph is significant because the judge states Miss Pusey was not a witness at the trial, but even on the assumption that she was doing her best to keep FXS and others safe from harm, it would not, as submitted by Miss Walker, render each face-down restraint any less of a battery. There is an inherent risk to safety in the use of face-down restraints, as they may cause breathing problems. So, she even dismisses the conclusion that even if Chrissy Pusey had been doing her best to keep them both safe, that wouldn't have undermined her finding on the issue of battery, which the appellant contends is inconsistent and for all the reasons I've already said.
And that's the difficulty with the suggestion that hostile intent forms an ingredient, which Lord Gough rejects. One
Yes.
can have entirely well-meaning and application tools, which, as it happens, is not reasonable in all the circumstances. One sees it in the police officer cases. It's more than is reasonable in the circumstances. It doesn't mean that it's not well-meaning, but you can be well-meaning and commit a battery. Otherwise,
Indeed.
an inconsistency.
Or because the judge has ignored the reality of the situation in relation to these three incidents and the evidence of the defendant's well-informed witnesses. She's ignored the context. And what was Chrissy Pusey expected to do in that situation? That she hasn't addressed that issue. If the conclusion is that what she did was unreasonable by implication, then that there should at least be some analysis as to what she ought to have done in order to address the situation that she found herself in. And if the answer to that is she ought to have got the respondent onto his back, then that would be that wouldn't be realistic. Because when somebody's trying to hit you in the face or trying to hit you otherwise and kicking out and trying to bite you, you're not going to have the time or space to attempt manoeuvres that might be ultimately consistent with your training. You're going to, as a default position, you're going to apply your training, but if that isn't successful, you're going to protect yourself. And the concern here is that the judge has not addressed that very important context.
Have we covered battery now? This week?
I think we have. I'll move on to false imprisonment.
Yes.
Thank you very much. I've made the point already that there's no analysis of the incidents in question. The analysis relates to the use of the towel method. The 14 occasions are set out in the supplementary bundle. May I just direct your Lordship's attention to one of those occasions at page 102 in the supplementary bundle. It's the occasion on 15th of May 2009 from 5:15 onwards. The judge has found, and this is at paragraph 125 of the judgment, that the towel method on one occasion, namely the 15th of May 2009, this method was used from 5:15 p.m. until 10 p.m. and then she awarded damages on the basis of that lengthy period of so-called false imprisonment. If we actually look at the note, it's a shorter note than we see in relation to the other incidents, but it's clear from the note that this was not a continuous use of the towel as stated within the judgment. From tea time, when he ran out of the house, the respondent was kept very close to adults. He needed lots of support and restraint to remain in his room after coming upstairs. At times, this involved holding the door to with a towel wrapped around the handle inside. So at times, not on a continuous basis. This need continued up until 10 p.m. The need being him needing lots of support and restraint to remain in his room. After which he gradually settled to sleep. Second, the respondent was prevented from disturbing the order in the house and prevented from putting himself at risk by touch support. We don't actually have the record from earlier in the day, but he'd been setting off the fire alarm and misbehaving, etc., which is the background to him being in his room at this time. But the appellant admits that document cannot be interpreted as the towel method being used throughout that period of time. That is simply a misinterpretation. The evidence that the judge failed to take into account, although at paragraph 34 she did accept that the towel was not used to close the door completely or to secure the respondent in his room. It was used to create a buffer between the respondent and his carers when he was behaving violently. So, notwithstanding that starting point, and notwithstanding the extensive cross-examination of Carol Day, who had direct knowledge of the use of the towel method because she was responsible for implementing and supervising it. And we have transcript references that I will provide your lordships with to that effect, notwithstanding her evidence that this was only used as a last resort in order to avoid the need for excessive physical restraint, that the door wasn't closed, that communication was maintained at all times between the respondent and the carer, and that the context in which the towel was used was short-lived in order to create a buffer to protect both parties. So the context wasn't to detain the respondent, it was in the heat of an outburst to maintain distance between the respondent and the carer to avert injury.
You took us to the supplementary bundle 102, the 15th of May incident. Did anyone give oral evidence about the 15th of May incident? I don't think they did.
No, my lord, no.
So the judge has only the document to go from and finds as a fact that the towel method was used from 5:15 till 10 o'clock.
Well, that's not what the document says. May I just remind myself, because Carol, I'm not sure Carol Day was cross-examined on that point. If she was, I'll find that and submit that over the luncheon adjournment. But Carol Day was cross-examined on many towel-related issues. But for the judge to conclude that for all that time the towel was being used is simply not justified on the law.
That incident seems to me, at least arguably, speaking for myself, to be in a class of its own, because it's very much longer, supposing the judge is right. Keeping somebody in their room 4 3/4 hours may be very different from keeping them in their room for 10 minutes, 20 minutes or half an hour.
Well, my lord, I recall Carol Day was cross-examined on that note, and I will find the reference, which I can't at this particular moment, but might I add that he was a child. The appellant was in loco parentis. It was perfectly legitimate for him to be sent to his room if he was misbehaving. We've seen the policy that permits
Well, I
that
don't
as
know.
a sanction.
I think the respondent's case is it isn't. So you have to confront that.
I'm sorry, my lord, I don't.
It isn't okay that he be sent to his room if he's misbehaving.
Well, he
That may be
can.
a case against you.
but he can be. That's a permissible sanction, as set out in the policy, which I referred you to earlier. I'm sorry, have I misunderstood, Your Lordship?
I thought, and perhaps I've misunderstood, I thought the claimant's case is that it is absolutely forbidden to detain a child in his room.
Yes, the claimant's case was on the basis that this wasn't secure accommodation, so
Yeah.
he couldn't be locked in his room.
Yes.
But the defendant's policy permits the sanction of sending a child and requiring him to remain in his room if he's misbehaved. And
Well, we'll
that,
see what Miss Walker says, but I think the claimant's case is that's as maybe, but the tort of false imprisonment is committed if somebody is confined, at least partly, is confined to a space from which he would prefer to move. If he's a child, it may be okay with the prior written agreement of his parents, but otherwise it's unlawful. I think that's the case against you.
well, my lord, that if that's the case, that's most unfortunate, because it would mean that it would be impossible to residential children's homes, because children misbehave and they have to be subject to sanctions. And the suggestion that this school didn't have the authority to send the respondent to his room when he misbehaved is not accepted.
I understand that, but there's a difference between sending to the room if they misbehave and by some form of physical barrier preventing them from coming out. Is it your case that there would have been nothing wrong with having locked doors and locking the doors? That wouldn't have
No, he
amounted
wouldn't
to
have been
false
locked in his room, and nor was he, and neither
No,
was.
I know he wasn't, but is it your case that it would have been lawful to lock him in his room?
No, it wouldn't have been. No.
What's the difference in kind between locking the door and holding it shut?
It wasn't held shut, my lord.
Holding it
That's an
in a
important
position
distinction.
where he can't get out.
Well, there's no evidence that he was trying to get out. That's the whole point. The evidence is that he is trying to attack a carer in order not to apply physical restraint, or because a physical restraint might not be possible. The carer withdraws, but still has to keep an eye on the claimant. And as the carer is withdrawing, the claimant is invariably still trying to attack the carer. So it's not that the...
Pause for a moment. I mean, I've looked at all the notes. They're not all the same. That
No,
might
they're
be
not,
true of
no.
one or two of them. It strikes me that in relation to a number of them, they're doing it because that's the best way of just trying to keep him to calm down. And he's throwing, as they put it, sometimes throwing his toys around. If they think the best way to de-escalate, to calm him down, is just to keep him in his room for 5 minutes, and then another 5 minutes, and then another 5 minutes in one case. So it's not always protection from attack. It's what you would describe as perfectly sensible de-escalation strategy. It's with the carer there, conducting the strategy, but nevertheless it is a strategy to keep him in the room, to calm him down.
Well, my lord, I'd have to look at the notes again, but in the vast majority of the incidents, he's trying to attack the carers. That's why they have withdrawn behind the door. But they're still communicating with him. There's no evidence he's trying to get out. And if he was trying to get out to attack somebody, then they'd be perfectly justified in restraining him and putting him back in his room.
Why is it relevant as to whether he was trying to get out or not? If the door were locked, just on the hypothesis that the school was using locked doors, would it be any less unlawful simply because he accepted it and didn't try and get out? Didn't bang on the door,
Well, my lord,
saying,
that's
let me out, or wasn't able to say I wanted to get out, I've just got to lump it because that's how it is?
That's a very hypothetical situation which doesn't chime with the present case.
Well, I'm testing whether it is relevant to the issue of whether someone is or is not imprisoned, whether they are trying to get out. I'm not myself convinced that it is.
Well, it may or may not be, depending on the...
I'm testing that by reference to a situation which I thought you accepted would amount to imprisonment.
Well, this is not secure accommodation, and so the school didn't and wouldn't have ever locked a child in his room. But again, we go back to context. It's the context that is relevant. And to answer the question, does there need to be an intention to leave the room? Probably not in all situations, but that's not, that hypothetical question in my submission isn't helpful in this situation, where we need to look at the context in its entirety, which is that, again, a badly behaved, violent child trying to attack carers who, in order to minimise physical restraint, because they've been asked to do so by his father, have, on occasion, not very often, and not for long periods of time, used this method to protect themselves and the claimant in the height of a crisis. And then they very quickly removed the towel and calmed him down. And in my submission, the first question has to be, is that detention? and in my submission, the answer is no, it isn't. That's that's to ignore the context in which these incidents occur. They have to be taken as they are, not in some hypothetical framework.
What's the right way of looking at it? That it is a restriction of liberty, which might, in some circumstances, be a false imprisonment, but that it's not unlawful in this situation because all the circumstances that you rely on make it reasonable to behave in that way in these particular circumstances. So it's a question of lawfulness as opposed to whether there is imprisonment as the...
Yes, well, Lord, that I wouldn't disagree with that analysis.
Thank you.
I'm not sure, beyond the points I have already made about the towel method, that any further background context would be helpful, and unless I can assist further on that issue, I'll move on to aggravated damages.
Yes.
Well, obviously, you're aware of the basis of the awards of damages. They included an element to account for what the judge, in her second judgment, considered to be either insulting, malicious, oppressive, or high-handed behaviour by the appellant. The basis of her decision to that effect is set out at paragraph 17 of the second judgment. First of all, the appellant's failure to appreciate the significance and seriousness of a member of staff using a face-down restraint. Secondly, the appellant's failure throughout the litigation to acknowledge the prohibition on face-down restraints, and, in her words, some witnesses refused to accept the plain wording of the daily incident reports. And thirdly, the failure of Mr. Vince, the appellant's social care expert, to make reference in his report to the prohibition on face-down restraints in the appellant's policy. She concluded that the reluctance to acknowledge the breaches of the policy went beyond different interpretations of the facts and legal issues under consideration. Well, Lords, if the judge's conclusion is correct, it will be impossible for me here today to continue to advance the appellant's case without being described as being high-handed or arrogant or failing to acknowledge points that are entirely obvious. That cannot be correct. All the appellant has done and did at first instance was to present his evidence via its professional, articulate witnesses and its interpretation of the records in the way that it, in its professional capacity, considered were appropriate interpretations. Mr. Vince was the only expert assisting the judge who had any experience of applying restraints or working in a similar setting, and he supported the appellant's contention that there was no concern in relation to Chrissy's conduct for the reasons I've already articulated, and in relation to the town method, that he himself had deployed that method in his own residential school settings. And so to conclude that that evidence went beyond different interpretations of the facts and legal issues is, in my submission, setting the test for aggravated damages inappropriately. And the reference to the way in which the litigation has been conducted, not elaborated upon any further, is also not accepted. The litigation was conducted fairly and proportionately, and it's not accepted that any of those involved in the defence of this claim can be criticised. It also has to be, or we shouldn't lose sight of the fact that the judge did dismiss all of the respondent's allegations of negligence, which is what consumed the 9 days of evidence. And so when we come to the interpretation of battery and the false imprisonment, those findings were effectively add-ons bolted on to the substantive claim, which was dismissed. The further point against the judge's finding that aggravated damages should be awarded relates to paragraph 33 of the second judgment, where she states there was no evidence that the school sought any advice at any stage between the relevant dates, and continue to use the towel method even after the father raised objections. Lords, the best expertise lay within the school itself, and so where the respondent was subject to input from a team of multidisciplinary specialists, including Dr. Karen Onions, the clinical lead, from whom the court heard evidence, and the head teacher, Andrew Lowe, and others. And so to suggest that the school's failure to go outside its own expertise somehow justifies an award of aggravated damages is, again, in my submission, misconceived. Well, those are the short points in relation to the aggravated damages award. Unless I can assist further.
Just one point. Clearly, when we get to this stage, we can see from paragraph 27 that the judge did consider separately each of the 14 incidents. Reference to how long they took, and that must have been taken from the notes themselves. But you say that
Yes.
the fact that she didn't mention them in her first judgment leads to the conclusion that she hadn't considered them individually.
Well, that's the first point, but the second point is that although she's put some timings in the second judgment, she still hasn't analysed the actual mechanism of the incident. There's no analysis of the factual.
No, I was just on that, and it may not be one of your more important points. That there was nothing in the first judgment to suggest she'd given any separate consideration to each of the incidents. And you're right that she doesn't, in this judgment, talk about the nature of the incidents, but that's because she's on a slightly different exercise.
Yes, no. My learned friend provided her with the timings, I understand, which she obviously considered, and yes.
I see.
don't have any. May I assist on any further points?
All right, we'll break off now and come back at 10 to 2.
All rise in favour.